let's speak with a lawyer on the back of the happenings. Osman Alhassan is a private legal practitioner, and this is a subject he has also followed. Counsel, good morning to you.
Good morning, and good morning to your listeners.
This is a rather unfolding event that a lot of people say they saw coming. From where you sit, did you also see it coming up until this point?
Can you take the question again, please?
Right. What I'm asking is, you've seen how the case has traveled since December 8th, from the counting and the collation of the results up until the injunction application by the court to the EC and the Clerk of Parliament, making it known to Ernest Yakumi that this is what he's getting himself into if he decides to be sworn in, Ernest Yakumi going ahead to be sworn in and all of that. Did you see the case traveling up until this point that an arrest warrant has been issued for Ernest Yakumi?
Well, I would say yes and no. Yes, because as a matter of course, if you disobey court orders, this is what it will result in. So as a matter of law and as a matter of course, that is what should be expected. But I don't have any reason to have expected that an honorable member of our parliament will be the subject of that legal disobedience and the enforcement of such a court order. Since he undertook to go against the court orders, I expect him to be able to go and answer the court why he decided to do what he did. Because if there's a court order restraining you from doing something or enjoining you from doing something, and you disobey the court order, what is ordinary? What is the necessary effect is that the aggrieved party will hold you to contempt of court, or the court itself can hold you for contempt of court. So but contempt of court actually is a conduct you have put across that undermines the administration of justice, or that brings the administration of justice into disrepute. And so sometimes it can happen without a court order, and it can happen with a court order. And that's why we have infashi and exfashi kuria. I don't want to go into all that. But the point is, once there's an order, and you have done something contrary to it, you will expect that the court will hold you to contempt. And contempt is when you do so willfully. You see, I talk about bringing the administration of justice into disrepute or undermining it.
Right.
But what is necessary to that conduct to make it contempt is when it is willful. So when you willfully undermine the court or willfully bring the administration of justice into disrepute, you need to answer. And that's why sometimes when you are summoned to the court for contempt of court, the summons tells you to come and answer why, or to come and show cause why you should not be held for contempt. For it means that what it means is that the actus reus, the facts that give rise to contempt of court, have probably been established. Now they want the intention, and that intention can be gathered from questioning you. So when you are summoned for contempt, you have to be there personally, then with a lawyer to defend you.
Right.
So that they will be able to, court will be able to establish whether your violation of the court order was willful or otherwise. Because if you send a lawyer to the court without yourself to go and represent you in court in matters of contempt, they will not be able to establish the willfulness of your conduct from your lawyer. And you see, when you have been given an opportunity to be heard, we know that the opportunity to be heard is very fundamental to every judicial process, and without it, the judicial process may come to naught. And if there's an order, it might be nullity. But the opportunity to be heard doesn't mean that when you are not there for whatever reason, then the opportunity to be heard is denied. No, if you are giving a notice to be before the court and you decide not to appear to be heard, the court can go ahead to deal with the matters without you. And if you look at our rate of summons on forms, it is always issued by the chief judge. And you see at the end of it, they will tell you that upon the service, if you refuse to appear for the hearing, the court will proceed without any further notice to you. So it means the opportunity to hear can be given, but it is up to the party to exercise it or not. And if you don't exercise it, you can't raise it again as a matter that goes against whatever proceedings the court had engaged in. So for me, as your question, I didn't expect that after doing what he did, he will not be willing to present himself to the court to explain. Perhaps that's what we call purge of contempt. Perhaps you'll be able to purge your contempt by saying that it wasn't willful, it was due because of ABC. So, but if you fail to do that, and I think that's what has happened here, and that's why I said I didn't expect it to happen, because this is a member of parliament, and so we hold members of parliament in high regard, and they are the makers of the law. So we least expect them to be the ones breaking the law and violating court orders, because without court, there will be no democracy. Without democracy, members of parliament have no job.
Okay. Lawyer Hassan, when an arrest warrant is issued, what does it mean? And in this case, what does it mean for Ernest Yakumi?
No, an arrest warrant is basically a permission to a law enforcement officer or any individual to effect an arrest of a person who is alleged to be an offender of the law. There are circumstances you can arrest with or without warrant, but I don't think that's what we want to take the public through now. But the point is that at the instances where it is appropriate for an arrest to be effected with warrant and the warrant is issued, what it means is that the person should be arrested according to the warrants of the court and brought to the court to answer whatever charges the court has before it.
The minority in Parliament, although they are unhappy with the court ruling, they say that they are sure necessary steps will be taken to ensure that their colleague is law-abiding and that the right thing is done, although they are dissatisfied with the approach and they think that he has been treated unfairly. When we say the right thing should be done and they will take all the necessary steps to ensure their colleague is law-abiding, what could it possibly mean?
This is an acknowledgement that their colleague is not law-abiding, if you ask me. Because if the minority leader has to take steps to make an adult who is capable of knowledge of the effect of his own conduct and is educated, and on top of that, he's member of parliament, and they need a leader of the minority in parliament to take steps to ensure he's law-abiding, that tells me that they know that he's not law-abiding.
I see.
And so, but the steps they are going to take to ensure that he's law-abiding, to me, to be honest with you, is so vague. I don't understand what that means. It could either be an advice to him, it could either be some form of compromise being reached between maybe him and the other party. I don't, but it sounds a little vague. The only thing they can do is advise him, give him legal advice, and give him a lawyer, if he doesn't have one, to accompany him to the court under the circumstance. Otherwise, I don't see what they mean by ensuring that he's law-abiding. That's not the job of the minority.
Right.
To ensure that someone is law-abiding is the job of the priest. Yes, so when we are all supposed to be law-abiding,
right,
and if we are not, we are compelled to do so. It is not our own discretion to be law-abiding. But if a minority wants to take that, well, that can only be advisory. I don't see anything beyond that.
Counsel, finally, where do we go from here? How do we ensure that a certain right thing is done?
Well, if a warrant has been issued for your arrest and you don't want to be arrested, you simply submit yourself to the court or to the authority before whom the warrant is to be taking you to. So if the court issues a warrant for your arrest and you don't want to be arrested, you just present yourself. But if he decides not to, which is a discretion he might exercise, remember, everybody can exercise a discretion positively or negatively. So if you can decide to exercise your discretion not to obey the law. But of course, the consequence will not be your discretion. The consequence will not be your discretion. If he decides not to submit himself, of course, the warrant that was issued would be enforced. It would be enforced. Though he might have some parliamentary privileges, there are ways to navigate them in the legal proceedings. So that will be done, and that should be done.
Osman Alhassan, thank you. Thank you so much for your time with us on the program. Osman Alhassan is a private legal practitioner speaking with us there.